If you think paying off your house means your family automatically gets to keep it when you're gone, there's a part of the system nobody warns you about until it's too late. Every year, families lose homes that were fully paid off for decades, not because of debt, not because of foreclosure, but because one missing document turned a protected asset into a legal nightmare. And the worst part is that most of the damage happens after the funeral, when children discover the paperwork their parents thought they had either never existed, was filed incorrectly, or was missing one critical piece that made the entire plan collapse. In this video, you're going to see the 6 documents that determine whether your children inherit your house quickly and cleanly or spend months, sometimes years, trapped in probate court, paying attorneys, losing equity, and watching long-term care costs consume the value of the property. Most retirees only have one of these documents. Some have none at all. The people who actually protect their homes are usually not the richest families. They are the ones who handled this before a crisis ever started, while they were healthy, while they still had time, and before the law started working against them instead of for them. And there's one document near the end almost nobody talks about. It's not a deed, not a will, and not even a trust. It's only a page or two long, but without it, everything else can still fail. Families with expensive trusts still end up in court because this single paper was never prepared. Before we get to that one, we need to start with a document that has quietly protected senior homeowners for decades in a handful of states and still remains unknown to most people who desperately need it. The first document is called an Enhanced Life Estate Deed, more commonly known as a Ladybird Deed. The name became popular after stories connected it to former First Lady Lady Bird Johnson in Texas, and over time the nickname stuck. What makes this document so unusual is how much control the homeowner keeps while still setting up an automatic transfer after death. You sign the deed today, but you still own the home completely while you're alive. You can refinance it, sell it, take out a mortgage, revoke the deed, or even change your mind entirely without asking permission from the beneficiaries named on it. Nothing changes during your lifetime. But the moment you pass away, ownership shifts directly to the children or beneficiaries listed in the deed without going through probate court. That alone saves families enormous time and money, but the real reason elder law attorneys use this document is because of Medicaid estate recovery. Back in 1993, federal law required states to pursue repayment for certain Medicaid long-term care expenses after a recipient dies. Nursing home care today routinely exceeds $100,000 a year, and Medicaid often covers several years of those costs. After death, states can seek repayment from the estate. That's where families get blindsided. They assume the house is safe because it's paid off, only to discover the state has a legal claim against it. The Ladybird Deed changes that outcome in the states that recognize it because the property transfers outside probate. In many of those states, estate recovery only reaches probate assets. That means the house bypasses the recovery process entirely. The deed itself usually costs somewhere between $300 and $800 through an elder law attorney, which sounds small compared to what families lose without it. There's a scenario attorneys see repeatedly. A widow in Florida owns a house free and clear worth around $320,000. She later develops memory issues and enters long-term care. Medicaid covers almost 2 years of expenses at roughly $90,000 annually. When she dies, the state files a recovery claim approaching $180,000 against the home. Her daughter eventually sells the property, and more than half the proceeds disappear into repayment claims. If the Ladybird Deed had been filed years earlier, the outcome could have been entirely different. But there's an important limitation most people miss. This deed only works in a small number of states, including Florida, Texas, Michigan, Vermont, and West Virginia. Outside those states, using one incorrectly can actually create title problems that interfere with future refinancing or sales. That's why the second document exists. For homeowners in most of the country, the next option is called a Transfer on Death Deed, often shortened to a TOD deed. Over the last decade, more states have adopted versions of it under laws based on the Uniform Real Property Transfer on Death Act. Functionally, it works similarly to a Ladybird Deed. You name a beneficiary, and when you die, the property transfers automatically outside probate. But the protections are not identical. You still retain control while alive. You can revoke the deed, change beneficiaries, or sell the property whenever you want. The difference is that the revocation has to be formally recorded with the county. There's a paper trail, and informal changes through a will often do not override what was already recorded on the deed itself. This becomes extremely important because many families assume a newer will automatically replaces everything. In reality, the recorded deed usually controls the transfer. Another major difference is Medicaid estate recovery. Some states shield transfer on death property from recovery claims, while others expanded recovery laws to reach non-probate assets too. In those states, a TAH deed alone may not fully protect the home from long-term care expenses. Still, for many families, this document alone prevents expensive probate proceedings. Imagine a retired teacher in Ohio with a $240,000 house and one adult son. She files a transfer on death deed for less than $300. She dies years later without ever needing Medicaid long-term care. Her son files the death certificate with the county, and ownership transfers directly to him within weeks. No probate hearings. No drawn-out court process. No thousands in attorney fees. Without the deed, that same estate could have spent close to a year in probate with legal costs easily climbing into the thousands. This is why elder law attorneys often call the transfer on death deed the minimum protection document for homeowners in states that allow it. It's short, relatively inexpensive, and incredibly powerful, but only if it's properly signed, notarized, and recorded before death. The third document is what many attorneys consider the most flexible overall planning tool, the revocable living trust. This is where families start thinking they are fully protected, but this is also where a huge number of estate plans quietly fail. A revocable living trust is essentially a legal structure that holds your assets during your lifetime and directs how they pass after death. You usually serve as your own trustee while alive. You name a successor trustee, often an adult child, to step in later. The beneficiaries are typically children or grandchildren. But here's the mistake people make constantly. Creating the trust is not enough. The home has to be transferred into the trust through a separate deed. Without that transfer, the trust is basically empty as far as the house is concerned. Attorneys see this failure over and over again. Families proudly say their parent had a trust, only to discover the house was still titled individually. That means probate still happens anyway. A properly prepared trust package usually includes far more than the trust itself. It often comes with a deed transferring the property, powers of attorney, healthcare directives, and a pour-over will. Complete packages commonly cost between $1,500 and $3,500 through an elder law attorney. Online versions can appear much cheaper, but many skip the critical funding process where the house is actually transferred into the trust. There's an important distinction here. A revocable living trust avoids probate, but it does not protect against Medicaid long-term care costs. Because you still control the assets, Medicaid still treats them as yours. That's why the fifth document later on becomes so important. Consider a retired engineer in Pennsylvania with a home worth nearly $400,000. He establishes a revocable trust, properly deeds the property into it, and names his daughters as successor trustees. Years later, after his death, the daughters sell the home within a few months with no probate court involvement at all. The same estate without a funded trust could have spent over a year in probate and lost thousands in fees. The fourth document doesn't control inheritance. It protects the value of the property while the homeowner is still alive. Depending on the state, it may be called a senior homestead exemption, property tax freeze, or senior assessment freeze affidavit. Most homeowners have heard of these programs, but huge numbers never file the paperwork. Once homeowners reach a certain age, usually 65, many states allow them to freeze or reduce part of their property tax assessment. The savings over time can become enormous. In places like Texas, the school district portion of property taxes can effectively lock at the value from the year the affidavit was filed. One retired nurse in Houston filed her senior homestead affidavit right after turning 65. Her home assessment froze at around $180,000. Years later, surrounding homes were assessed far higher, and neighbors were paying thousands more annually in taxes. Her paperwork saved her roughly $29,000 over a decade. The incredible part is that these filings are usually cheap or free, but counties generally do not apply them automatically. Homeowners must actively submit proof of age, residency, and sometimes income. Waiting too long often means losing years of savings permanently because most states do not retroactively apply the exemption. The fifth document is where planning becomes much more serious. This is the Irrevocable Medicaid Asset Protection Trust, and it exists specifically to shield the home from catastrophic long-term care costs. Unlike the revocable trust, this one cannot simply be undone whenever you feel like it. Once the home is transferred into the trust, ownership changes legally. You can usually continue living there for the rest of your life, but you no longer directly control the property in the same way. There's a case pattern attorneys know well. A retiree in New York establishes an irrevocable Medicaid Asset Protection Trust in her early 60s and transfers a $400,000 home into it. Nearly a decade later, she requires nursing home care. Because the transfer occurred outside the 5-year look-back period, Medicaid covers hundreds of thousands of dollars in care costs while the home remains protected for her children. Without that planning, the property could have been liquidated to pay for care or exposed to estate recovery claims later. And finally, we come to the sixth document, the one almost nobody files, yet the one capable of making every other document fail if it's missing. This is called a certification of trust, sometimes known as an affidavit of trustee or memorandum of trust. It sounds insignificant compared to trusts and deeds, but this tiny document determines whether the successor trustee can actually act without going to court. Here's what happens without it. A parent dies. The child named as successor trustee tries to sell the house or access accounts held in the trust. The bank or title company asks for proof of authority. The child presents the trust paperwork, but the institution demands formal court confirmation instead. Now the family is dragged into hearings, petitions, filing fees, delays, and legal expenses that can last months. Meanwhile, the mortgage, taxes, insurance, and maintenance costs continue draining the estate. A certification of trust changes that entirely. Instead of handing over a massive trust package, the trustee presents a concise notarized summary confirming the trust exists, identifying the trustee, and outlining the trustee's authority. Title companies and financial institutions can move forward immediately without forcing the family back into court. One widower in Ohio had his trust properly funded and included a certification of trust recorded with the county. After his death, his son sold the property quickly with minimal legal expense. Comparable estates without that certification routinely spend months in court and thousands in avoidable fees just proving the trustee has authority to act. And this is why families who thought they planned perfectly still end up trapped in probate-like proceedings. They had the trust, they had the deed, but they missed the one document that allowed the plan to function smoothly after death. When you step back and look at all 6 documents together, a pattern appears. The families who protect their homes are usually the ones who acted early, before illness, before incapacity, and before panic decisions. The sequence matters. State-specific deeds first. Trust planning second. Property tax protections at retirement age. Medicaid planning while still healthy. And trust certifications to make everything enforceable when the time comes. Trying to do this alone can create disastrous mistakes because every state handles these documents differently. Filing the wrong deed in the wrong state can damage title records. An improperly prepared transfer on death deed can fail entirely. A trust that never receives the property does absolutely nothing. The difference between a correctly executed plan and a failed one can literally be the entire value of the house. That's why experienced elder law attorneys focus not just on drafting documents, but on making sure they are signed correctly, recorded correctly, and funded correctly. Most initial consultations cost far less than what families lose through probate, tax mistakes, or nursing home exposure later, because in the end, paying off the mortgage is only one part of protecting a home. The real question is whether the law recognizes your plan when your family needs it most. And for thousands of families every year, the answer depends entirely on whether these 6 documents were already in place before the crisis ever began.